you want it a little closer, or do you like what the podium is? A little closer? Judge, we're going to move the podium up a little bit closer, if that's all right.
Fine. As long as my court reporter can deal with it, it's good. Mr. McCord, how are you? Not too happy right this moment.
Yeah.
It's 3 till. and-
Back here, because the...
Yeah, well, they're going to come in and want 10 minutes to set up, and they're not going to get it.
Janet, this is as far as we can go because of the cord for the...
Yeah, that's great. It just seemed to me that there might be that's good. Still here.
I know, we need more itineraries.
No, well, that for sure.
Well, if anybody just wants to donate quickly, we need to get some money in the bank, so. Okay.
Morning. How are you?
Morning. How you doing, sir? Morning, sir.
Morning.
Morning.
How you doing?
Greg, did you want to say hello to somebody real quick, or?
I'm sorry, Sam.
No, in the back.
Good, good.
You want to say hello to somebody?
Oh, yeah. I said hello. I'm fine. I can hear you.
Okay.
That's all.
I'll be back.
Thanks. I'm out. Thanks, Your Honor.
Then later you may, or I'll sit around.
We got to put something on the record real quick, David, and then
I think we're either 16 or 17
Well, when I said,
Also, when it already solved it.
hey, we can't take that.
Get this end.
Yeah, right?
We solved the issue.
Sure.
See the bios on there.
you ready, Sam? Good morning, everybody.
Morning, Your Honor.
Let's deal with a little housekeeping. We had talked about Laughlin issues before. Mr. Zion, has there been anything further along those lines?
Your Honor, I did make an overture to the defense if they were willing to engage in negotiations. Speaking off the record with Mr. Baez last week, not that it was an offer. We had not talked to the victims' families as we were required to by Marcy's law. And I said everything would be contingent on speaking with the victims' families, speaking with the rest of the prosecuting team, and of course with Mr. Tyak. But I said if he was willing to engage us in negotiations, we would be willing to take murder off the table and have him plead to a series, in a large series. That was something we would have to work out. But in excess of 10 reckless homicides, do a PSI, and then argue. It would be my understanding that his exposure would be 3 years on each one of those because they are F3s, and that there would be no presumption or nothing mandatory about prison. However, his exposure would be up to 30 years in prison for that. I also said I didn't think there was anything that if he were to get prison would bar a judicial release. I asked him to confirm all of that with Ms. Menashe. I said that was not an offer, not something solid, but that is a starting point if they are willing to engage us in negotiations. And we heard nothing back on that issue. So I assume that is a non-starter. That's all I have. Thank you, sir.
Mr. Baez?
Yes, Your Honor. Mr. Zion is correct. He and I engaged in some discussions in what I found to be a extremely reasonable starting point in the conversations. There was no formal offer, but as I had mentioned, they were extremely reasonable. So much so that I had significant discussions with Dr. Husel, and Dr. Husel is expressed to me he is innocent and wishes to move forward and have his day in court and trust in the system and in your honor.
Okay, does everybody feel that we've met our obligations under law?
I do, Your Honor, thank you.
I do.
You have stuff coming in the back of the courtroom?
Yes, Judge, I apologize for just
It's okay.
bringing in some of our exhibits.
I don't think I've got an easel big enough for the one.
Will the state be allowed to look at whatever they're going to show the jury before they...
Well, my standing rule is if you're going to show it to
Absolutely.
the jury, you exchange it back and forth.
We certainly will do that in the break.
All right, thank you. And do you have the vials that we let you look at last week?
I put them back on your table in the white bag. Put them back on state's table.
We got our jurors?
Oh, wait, no. We'll get them to you, sorry. Somebody just told me that.
All right, thank you.
Morning, Your Honor.
Come on. We were short one juror a minute ago.
Short one, juror.
Mr. Stein, can I talk to Jane for a second? Jane, yeah.
When we're at council table, but when we're out in the world, we're getting near people. Is that okay with everybody? It's what you're comfortable with. It's what you're...
No. I was just showing her, we've got it all set up in 6-app for you all. Okay, you can see, I can keep track of where anybody enters it. So, yeah, we're gonna run out of space real quick. Okay, cool. I just wanted to know that we were able to see what was going on there too, so. Yeah, go ahead. We're still waiting on a juror.
Well, it was shitty, super bad weather, so maybe they're stuck, like not giving themselves enough time. This is nothing. Keep time. I guess that's the measure. Hey guys, I think we sent you an email This will be the first picture she'll have, and Gillette will identify that, just that that's what Carmel used to look like. And then we have her opening, and then not these pictures, but we go to one, enter. And then when she says the names of each victim, these are the photos that were in that big, timeline thing. We'll stop with that.
Yeah, we have 5 grand.
All right.
I hollered a minute ago.
If you put something in that doesn't come out, they don't know. So.
Yeah. I just wanted to let you know what we were planning on this. Yeah. All right.
It's still there, no?
Okay, make it work.
It looks like it's still there.
We still have one juror missing. David is going from room to room to figure it out.
Judge, is that plexiglass still there? I thought we were.
No, the frame, they left the frame up. If you go, it's wide open there, but the frame is
Playing
still
tricks on
there.
my mind. It really looks like it's still there.
Well, there's going to be a discussion later this morning with the second floor about why.
About why it's not there?
Well, the glass is gone.
Oh, okay.
Okay, well, they left the frame. Why?
Yeah.
Because they're gonna put it back in, and it is structural.
Okay.
It is.
No good deed goes unpunished.
Morning, Sam.
And she's a major or is she an alternate?
Yeah, that's what it's going to be.
Well, there was a gentleman that said one of the garages was full, but he made it park.
Okay.
Judge, we have some concerns about the feed, though.
Okay.
We're being advised that our whispers are being picked up on the feed. And, of course, that would impede any attorney-client
You should be able to
communications.
hit your mic off.
So green's on, right?
It's off. Green is on, right?
Green is off.
Off.
Yeah.
Try it.
Okay, so green is off.
Yeah.
Green is, so this is off now?
See, there, you have this behind me, but the green means that it's off and you can talk. No light means it's on.
It doesn't seem, yeah, I agree, red should be off.
Okay, someday you can have your own company and that's the way you can sell it.
That's what I'll say, that's what I'll do, Judge.
So you can hear me now?
Do you have somebody up on 6C?
You have someone on the street that Michelle can hear me, okay?
That makes my brain melt. The meeting is off.
Send this to James.
Okay. Adjourn.
Get it lined up for that.
Yeah.
Yeah, but she's not a charged count. But when the 1,000 happened, he talked to Greg Trespass. And Trespass, that's his typical dose.
I'm just gonna tell you, I think there's a lot of I read all of it.
Celebrate the version.
Sound like they're having a good time in the back.
That's why they disguised it.
Michelle just texted, that was like, as if she could still hear her.
She was telling you anything like that. Not only abandon that, she tear it down.
So she didn't hear her.
Okay, all rise.
So we're getting the same issue from online.
Okay, on the break, we'll try to deal with it with Paul.
I would prefer that.
Yeah, I think so too.
Is there a button on the back or something?
Turn it off too.
Unfortunately, we have to have two seated over here.
I'll be right over there.
Yeah, thank you. Please be seated.
Good morning, ladies and gentlemen of the jury. How are you today? It sounded like it was a bit festive in the hallway. Okay, we're going to move on to the next phase of the trial. This is the opening statements. It's what the lawyers think it's going to be. It's like the trailers at a movie theater. They're going to tell you what they think the evidence is going to show. It is not evidence itself. That'll come in the next phase. But with that, Mr. Zion, are you ready to proceed?
We are, Your Honor.
Ms. Grubb, I'm sorry.
Yes, thank you.
Okay, before you get started there, if you all are comfortable, you can,
As far as the masks.
as far as the mask, because you're in your own little cubicle there. Okay? I want you comfortable. Now, when you go, you got to put it back on. Okay? Sorry about that, Ms. Grubb. You may proceed.
Thank you, Your Honor, defense team, colleagues, and members of the jury. Good morning. My name is Janet Grubb.
It is my pleasure to finally address you this morning. Mount Carmel West Hospital was an unlikely crime scene. The hospital formally opened in 1886, having secured the services of the Sisters of the Holy Cross. The training school for nurses was opened in 1903. The first graduates received their diplomas in 1906. 8 sisters were included in the class. The school still exists today and is now the Mount Carmel College of Nursing. This location was known as Mount Carmel West and was one of the 4 facilities that comprise the Mount Carmel Health Systems. Mount Carmel West moved in 2019 and is now known as Mount Carmel Grove City. Mount Carmel Health System is the second largest healthcare system in Central Ohio. Our evidence will show that they employ approximately 9,000 total employees and over 2,000 doctors in their numerous outpatient facilities and their 4 hospitals. Mount Carmel East near Reynoldsburg, Mount Carmel Grove City in Grove City, Mount Carmel St. Anne's in Westerville, and Mount Carmel New Albany Surgical Hospital in New Albany comprises the system. Mount Carmel Health is owned by Trinity Health, a Michigan corporation. The Hospital of Mount Carmel West occupied a unique position in the areas of west and southwest of downtown Columbus, including Grove City and other small towns in the region. The hospital's ethic and profile fits the patients it served and the people who worked there. Hardworking, family-oriented, religious, trusting, generous. If you grew up in this area, chances are you stayed there. This is a painful family affair with no end of pain on so many levels. Our evidence will further show the pain relates certainly to the loss of the lives, who we will prove were murdered by the defendant, but also extends to the loss of careers, jobs, friendship, financial security, and trust in healthcare professionals and institutions. The evidence will reveal that this case unfolded one surprising step after another. The pharmacy staff at Mount Carmel West became alarmed about certain drugs ordered and administered at the direction of William Husel. Their concerns were escalated to hospital administrators, other physicians, and ultimately to the top medical officer at Trinity Health. The setting for the use of these drugs was the night intensive care unit at Mount Carmel West. These medications are powerful, potent opiates, benzodiazepines, and paralytics employed in the treatment of seriously ill individuals who are placed on ventilators to help sustain their lives. The evidence will show that these drugs were prescribed in massive doses in combination with one another. During the ongoing COVID-19 epidemic, we became aware of the use of ventilators to care for people needing life support. Being on a ventilator was not and is not a death sentence. People do come off of them and live. Unfortunately, that was not the case for the victims in this prosecution. The medical testimony in our case will demonstrate that when an individual is placed on a ventilator, they should be highly monitored and expertly managed to determine their physical state and to preserve life. This is a highly dramatic event in a person or a person's loved one's life. There are no guarantees when you go on a ventilator. If you are conscious going on a ventilator, you must know that you may never wake up alive again. This is the state in which we find our victims. Our evidence will establish that many of our victims were elderly. Some were younger than 40. They had multiple medical conditions. Many were extremely serious. They had families, lives, and people who cared about them. They went to the hospital for help. Several of them were not sick enough that they were destined to die during their hospitalization. They all had one thing in common. William Husel was the nighttime ICU physician who ordered lethal levels of drugs or a combination of drugs with their removal from a ventilator after their loved ones made the excruciating decision to withdraw care and remove them. A fair question would be, how did this happen? These drugs were obtained through Mount Carmel West's pharmacy system from a drug dispensing machine known as a Pyxis machine. They were located in the ICU. Often, Husel ordered drugs verbally and overrode the hospital's procedures for pharmacy review. At the time of the majority of these cases, in order to be within hospital policy for an override, it would either need to be an emergency situation, which our evidence will show is typically not the situation with an extubation, or Husel would need to witness the drug's administration himself. These drugs were removed in massive amounts, well exceeding reasonable dosing for the procedure of removing ventilator support. Physicians trained in their use will testify that the doses used were at levels that could not be supported by the patient's medical histories or current circumstances. They will further testify that the drugs ordered by the defendant caused the death of the victims as alleged in the indictment. The nighttime ICU at Mount Carmel West did not have a dedicated pharmacist. 2 pharmacists served the entire hospital during the night shift. If a physician ordered opiates or benzodiazepines on override from the Pyxis machine and the drug was administered, there was never pharmacy review for appropriate use. In the case of defendant's dosing regimens, his practice of overprescribing fentanyl and other drugs continued without oversight for years. You will hear how well-respected defendant was at Mount Carmel West. The nurses, pharmacists, and other doctors liked him and thought he was a good doctor. He was attentive to the patients and willing to share knowledge. Doctor of the Year honors were bestowed on the defendant during one of his first few years at the hospital. He was well known for his training at the Cleveland Clinic in anesthesiology and critical care. He was and is, in many cases, still highly regarded by many of the young nurses who worked on the ICU at night. Many new nursing school graduates, ambitious, bright, and in the defendant's thrall. They looked up to him, trusted him, and had extreme difficulty in questioning his orders or methods. His ability to verbally provide alleged reasons for his dosing, coupled with his training as an anesthesiologist, caused the nurses and pharmacists to accept his practices as appropriate and even essential. Our evidence will dispute his reasoning through our experts' explanation of the proper standards of medical care. Members of the jury, this case is a mountain of evidence, information, technical data, and criminality against 14 innocent and seriously ill individuals. Our evidence will show that this case is not about the following. It is not about fentanyl as a drug of abuse. It is not about drug diversion from a pharmacy. It is not about Medicaid fraud. It is not about a hospital system desperate to survive. It is not about taking comfort care from the dying or wanting people to die in pain. It is not about assisted suicide. It is not about criminal behavior of anyone other than the accused, William Husel. It is not about civil judgment for or against anyone involved in this case. It is not about wrongdoing by Mount Carmel as an institution or its employees, including administration, nurses, and pharmacists. This case will touch upon the following concepts: medical malpractice or negligence, group dynamics in the medical profession, financial pressures in the U.S. medical system, system failures in large institutions, the culture in the ICU at Mount Carmel West, the assumption in a medical setting of good intentions, the Catholic Church principles of sanctity of life and care for the sick, needy, and/or elderly. Our evidence will demonstrate that this case is about the following: standards of medical care, the rights of the critically ill and their families, including right to self-determination, right to the truth, and right to sit vigil over the dying as they progress towards the time of their natural death. It is also about the properties and interactions of powerful drugs, including opiates, benzodiazepines, and paralytics. We will demonstrate that our case is also about the science of maintaining the critically ill in an ICU setting, including appropriate pain management as used by other physicians at the hospital. It is about the science of managing pain within the palliative withdrawal of care, including removing a patient from a ventilator and controlling their pain and/or agitation upon withdrawal of care. This science includes concepts embodied in a set of orders maintained at the hospital and used by other ICU and palliative care physicians. Similar dosing practices comprise the standard of care in the medical profession. You will hear how these medication regimens used by other physicians involve opiates and benzodiazepines in a much lower equivalent doses. Mount Carmel's palliative ventilator withdrawal order set, in existence for all of our 14 cases, but the first, recommended a pre-dose of 5 to 10 milligrams of morphine before extubation and adjusted amounts after extubation to keep the patient comfortable. It also suggested 2 milligrams of Versed, a benzodiazepine for agitation or anxiety. Oxygen therapy was also suggested. The conversion of morphine to fentanyl is roughly 10 to 1. Translated into fentanyl, the pre-dose would be 50 to 100 micrograms. Defendant administered 600 to 2,000 micrograms at one time. The defendant's pre-doses were 6 to 10 to 20 times the recommended dose of fentanyl, depending upon the patient, and 3 to 5 times the dose of benzodiazepines. The state's evidence will further show that opiates and benzodiazepines had a synergistic effect and create a medication multiplier, not a simple 1 + 1 = 2. This combination of drugs creates an overwhelming risk of respiratory depression. Our evidence will also show that after an extubation, the standard of care involves maintaining a caring presence at the patient's bedside, monitoring pain, and ongoing titration or adjustment of the medications to keep the person in a state of comfort, allowing them to pass naturally. This is in direct contrast with the defendant's practice of administering an enormous shot in a short period of time and calling it a day. Our evidence will also show that Mount Carmel Hospital System ran an internal audit, and the defendant was the only physician in the entire hospital system using fentanyl and benzodiazepines in these grossly inflated doses for this purpose. Ultimately, our case is about the fact that William Husel caused the death of our 14 victims. You will hear and see for yourselves the way this case was referred to the Columbus Police Cold Case Homicide Squad and Franklin County Prosecutor Ron O'Brien. Police involvement came on the heels of the Mount Carmel Hospital internal investigation or review of the defendant's dosing practices. The hospital's review was separate from the police investigation and resulted in the termination of Husel, pharmacy staff, and nurses. These concerns were eventually directed to his practice when he ordered the removal of people from ventilators, supporting their breathing, along with other life-preserving therapies. These homicides are loosely classified as cold cases. The reasons for that are the period of time between the death and the suspicion of foul play. Most of William Husel's victims died without any question regarding the reason for their demise. Fortunately, we have the actual medical records for each of the deceased. The records demonstrate as much relevant medical information as possible, short of an actual autopsy. Based on the drugs administered involved in these cases, the evidence of death and why they died will be clearly proven by the state's evidence. The state of Ohio will present a number of mainstream medical experts. All of them possess special certification in their medical fields. Many of them publish in their fields and teach other physicians in order to educate the next generation of practitioners. They have years of relevant experience and will testify that William Husel's dosing practices were unwarranted and unprecedented. The state's experts will establish that our victims' medical situations fall into several categories. Many were not in a position to feel discomfort, pain, or agitation. Nonetheless, they were administered large doses of fentanyl or fentanyl and benzodiazepines without being medically indicated. Several of our victims should have been maintained on life support for a longer period in order to eliminate all possibility of hope and to be observed. Others of our victims could have survived with appropriate care and informed decision-making by families. In this case, we will demonstrate that because the defendant was not acting in good faith and used drugs wildly excessive for the needs of his patients, this defense does not apply. We will present testimony from numerous physicians, nurses, and pharmacists employed at Mount Carmel West at the time of the murders. These individuals played a part in the events detailed in this case. They are not accused of criminal conduct. In each instance, the defendant ordered the administration of the lethal doses of medication. Our evidence will establish William Husel's actions caused the death of these patients. As we previously discussed, these people were quite ill and receiving care in an intensive care unit. The state's experts will establish that not all of these people were terminally ill on the date of their death, or at all during their hospitalization. We will prove that William Husel's acts were a cause of their individual deaths. We will prove through our evidence, all consistent with Ohio law, that the defendant is responsible for all of these deaths as the natural consequences of his unlawful acts, even though the victims had serious illnesses. The state does not need to prove the defendant's motive. However, his purpose will be very clear. The state's witnesses will demonstrate through actual, detailed medical testimony that given the physical condition, medical status, ages, and previous course of treatment of his patients, Dr. Husel knew exactly the natural result of his purposeful acts, and that therefore he possessed the intent to unlawfully end the lives of 14 innocent individuals. As William Husel possessed advanced training in the use of the drugs he employed to end the lives of his patients, the state will show that his actions were not mere accidental or medical negligence. They were, in fact, murder. The drugs used and the size of doses used in conjunction with other powerful drugs were important elements in determining his intent. But other behaviors were important too. These behaviors include what events were treated as emergencies or urgent, the timing of these procedures, the time of day of these procedures, how consent to proceed to comfort care was obtained and from whom. Other factors included the actual medical condition of the people that were murdered, and that some of the murdered could have left the hospital to go home or to hospice. As previously discussed, this case has many heartbreaking aspects, none more so than the loss of the patients of William Husel listed in the indictment. These people had names and families. Joanne Belisari, Ryan Hayes, Beverly Schertzinger, Danny Millette, Francis Burke, Brandy McDonald, Jeremiah Hodge, James Allen, Troy Allison, Bonnie Austin, James Timmons, Sandra Castle, Rebecca Walls, Melissa Penix. Members of the jury, thank you for your kind attention. We assure you that our case will provide all that you need to consider this case fully and to deliberate with confidence. The actions of the defendant speak clearly to us. After careful consideration of all of the evidence, we are confident that you will return verdicts of guilty against the defendant in all 14 counts. Thank you, Reverend.
Thank you, Ms. Grubb. Mr.
Members
Bias?
of the jury.
Your Honor, we need a moment to set up. If you could take a quick 5-minute break.
Well, if I give them 5, they won't love me anymore, so how about 10? Will that give you enough time? Let's take 10 minutes, ladies and gentlemen. Remember the admonitions?
All right.
We'll get started back here in a second. Have a wonderful 10 minutes. Be careful there. I hope that was the coffee mug and not you. Have a good break, guys. Okay. Anything for the
Nothing for the record.
anything for the record, Mr. Rhodes?
Okay, Chairman, thank you.
Anything on the record?
No, sir. We're
Any
going
for
to
the
call
record?
Paul and ask if we can get, I think everyone wants these microphones disconnected.
Okay. He was starting a video conference with ODRC, so.
Put this closer to you. I'm sorry. I won't. I promise not to stand over you. Let's push this back. Push this back forward. As far as back as you can go. That I think here.
But they tried muting him.
Big one here, right?
That works.
They would just turn that on arbitrarily.
I think they disconnected their own.
I just want to.
Now, the green light means it's muted, right?
I was just surprised, Judge. Green
But
means
also
go.
the green light.
I grew up with that.
When it's recording or when it's live, normally it's red. We're not using the recording system, so the mic's live.
It keeps coming on its own. I want them off my table. I'm gonna, if you don't disconnect it, I'm just gonna put it on the ground.
Sometimes I can hear you and then I'm talking.
Let's see, is that a felony in Ohio to destroy public property?
I'll be loud. What's that?
So what do we got here?
Take a look at it. Sure. Right back.
Yes, ma'am. Thank you.
And then Paul, not to add to your worries, but 6F, nothing's working up there except that people up there are really talking. That seems to be. Like they can see if there's anything that's going on down here. And so that's black. Oh, well, I didn't know that. So whenever time we use our PowerPoint, they can't see that.
They can see the PowerPoint, yeah. I want to be able to hear your voices, but they...
Well, I don't think you should block it. The jury's view of us.
So this is doses and dates. Some of this probably would be highlighted. Tracy here. Process of ordering. Order nurses, pharmacists, attendants. This basically is an outline and a timeline of events. Started in October.
Can I take pictures?
Yeah.
You're old school, I like that. I would still have a chocolate. And I'm assuming you're not changing the
If you see an error, you let me know, but I don't think so.
That's what I'm gonna check, just so we can verify. Oh, upside down. Anything going up there? I see that guy.
Yes.
It's always great to get back in the saddle, you know?
Sure.
So it's always great to get back in the saddle.
I'm trying to get the HDMI to work. But I'm trying to think.
He runs everything. So if you want something up here, you have to ask the judge's permission and then just tell him where you're at.
You can take that last one back. Take that.
Okay.
Well, not the.
This was.
You want this up? I got this.
You know, retire, whatever that is. You know, just do that.
So are you going to mark these as exhibits then?
I could just mark the dates, but.
Well, if you're going to be shining to witnesses, they should be marked.
Yeah, we'll do that if we get some
That's why I
witnesses.
left it.
Jaime, could you
Yeah.
cover this one up?
You know, I felt like I had something.
Yeah, I've got stuff in the tank, but it's, I'm worried about this part of it, because I'll probably talk to you about it. Because it's easy to sit up here and it's easy to sit out there, but when you go back, what you have to deal with.
It's the transition. I prepare myself because I knew it would be sometimes rough. And there are lots of different questions.
Yeah, let them see it. They can see it. Oh, actually, I would print it out here.
You got a PowerPoint plus all this? You know they won't be able to see half the
I
screen
just printed them
because...
out and David's looking through them now.
Okay.
So, do you have the clicker?
Which spot are you in back? Are you second table?
You can take this up.
Count back, first and second.
Actually, I wonder
Okay.
if we should put this back further.
It should bring up your computer now.
Okay, perfect. I'll set it up over there.
Okay, you're at the cart then. Are you going back? You're going back or you at the cart?
I'll go back.
Okay. Now you're gonna have to talk up because you're away from the mic.
I can do that.
Huh? Yeah, go ahead.
I can get you a copy. Do we have an extra copy? Even an older one?
Thank you. Appreciate it.
Okay, are you jacked in?
Yeah, I'm connected.
Okay, there you are.
Can they actually see
They're
that?
not going to be able to see that through the display.
I explained that to them.
They can't see that, if that's the case, so maybe we put this down. Yeah. I think I'll get you a copy.
While we're figuring out stuff, we just have Darcy or somebody run a copy for us. Sure.
Yeah.
Can't get through anymore.
Darcy, give me a quick copy.
That would I show.
How many copies you need, David?
2 copies, please.
Cover what?
The second big tall one, I don't think we're covering up, and you can always move it to front and do that one. The other big one, move it over there so it leans against that one, that tripod.
This one, what's that?
Yeah.
Okay, we're starting to get in front of the court reporter.
Well, I'm guessing you're not blocking this. I mean, they can all turn in their chair if it's right here, and that way it's out of everybody's way.
I don't know.
I don't think you're gonna be able to.
Okay, just a suggestion. I'm just, you've got that screen.
Yeah, no,
May be able to angle it right here.
Yeah, you know what, you're right.
I'd ask my court reporter if that's okay, if she's comfortable with that.
As long as nobody in the jury talks, it's fine.
Well, they shouldn't be.
Yeah.
Let's try that. I agree. Let's try to do this. See if that works. Even better. Put one up. Is that okay, Sam?
That's fine.
This one goes up.
Just don't let the jury talk.
Okay, great. Yeah, now we can see. This, I think it'll be good right here.
And this is why we have technology. Okay, we ready?
I believe so. I'm just trying to figure out if this is best here.
No one needed to see Judge Holbrook anyways.
All right,
I got my little alcove over here in my elevator.
Oh, I was wondering if Darcy had brought those back. I thought I saw her in here.
This is gonna, I gotta work around this. That's it. So why don't you just, you stand here, and we'll just work around it. I do. I'm good. Let's do this.
Go back. Was it?
Huh?
Go back. And then go forward. So start with one. Yeah.
Okay. I mean, we're on work. Yeah.
I'm a homebody, I'm a cancer, so, you know, I need help with something. I like to travel, but.
Grabbing the jury.
Sir?
She's grabbing the jury.
Oh, yes, sir. Just as yours. Thank you.
And you're the son, right? Yeah. That's tough. That's tough.
It's like the weather.
Why do kids do that?
Jose.
All rise.
Oh, you okay?
Yeah, thank you.
Okay, you can be seated. Thank you, ladies and gentlemen. Mr. Baez, we're going to continue on with opening statements. Mr. Baez.
Thank you, Your Honor. May I please support? William, Mariah. Good morning, ladies and gentlemen. Good morning. Have you ever thought of your death? You're in a hospital. Your body's ravaged by disease. Who do you want there beside you in those final precious moments? How do you want them to see you? How will you handle the fear that death is right there? The anxiety. As your body starts to break down and you gasp for air, and the pain of the disease that you're suffering from overcomes you. What do you concentrate on? Pain? Trying to breathe? The fluid in your lungs begins to rattle. There have been bad deaths, and that's the phrase you can all be familiar with by the end of this trial. Sometimes foam comes up in your mouth, you cough up blood. Dying is a terrible, terrible, ugly thing. In this case, I am certain for both sides, has created a terrible feeling within us because we have to face death. And it's absolutely something we never want to talk about, think about, or really look into. But there's one thing for certain. We will all experience it one day. Each and every one of us. That's the only certainty. So this case, ladies and gentlemen, is about 100% comfort care. A person's right to live their final moments in peace and dignity. No one is better to determine that than the individuals who are at your side in those final moments. This case covers a wide range of dedicated healthcare professionals, ranging from doctors, nurses, and pharmacists, as well as chaplains, other spiritual advisors. And the one thing that you all need to realize, that in order for you to recognize that if this is a murder case, that all of these people were either involved in a conspiracy to commit murder, either were conned by some suave doctor, or are perhaps the dumbest people that ever walked the face of this earth. Each and every one of these patients were not just seen by Dr. William Husel. And each and every one of these patients had multiple healthcare professionals in and around their care. And today I'm going to cover with you quite a bit of extensive information where you will hear things never before disclosed. You will be the new experts as to what exactly happened in this case. Now, my opening statement will be quite a bit longer than my colleague. And that's because what I want to do is I want to set you up in a framework of how you're going to view this evidence and what to look for and how it all connects. It's a complex case, and my job is to try and make it a little simpler and easier to understand so you can actually apply the law to it. And one of the things that you're going to recognize right off the bat is there's no such thing as a medical murder case. And that this is not a murder case. And it's far from it. William Husel was exercising compassion to his patients and tried to free them from pain and let their last moments on earth be ones of peace. Because that's what his patients would have wanted, and that's exactly what his patients' family wanted, even when they begged him to make sure that they were comfortable. Now, what I'm going to cover with you is first an outline of how we got here. And that's because it's really important, if you think about it. Everybody wants to know, how in the world did this all happen? How did we get here? And you're going to recognize the series of events that took place that are downright shocking. And there are going to be moments where I'm going to tell you, please take note of this. Because that's what I want you to look for as this case progresses. And after I tell you how we got here, I'm going to cover with you some of the issues with the law that this case simply cannot overcome. And I don't mean it as a technicality. I mean it as you'll see that because it's not a murder case, this case doesn't belong in this forum. There can be all types of criticism of these people, because I include them, including William Husel. There can be all types of criticism, but there will not be any evidence of a criminal act. To the contrary, you recall my colleague mentioning what this case is not about. Well, that's not what they want you to think about, and you're going to shortly see why. So, let me tell you first about who Dr. William Husel is. William is married to Mariah, a nurse we met at Mount Carmel, and they have two lovely, beautiful daughters. And I can assure you that they are what this case is ultimately about for William. William Husel is a local Ohio boy. Born and raised in Cleveland. His father worked in mass transit. His mother was a stay-at-home mom. Comes from a very blue-collar family. But as you can see, after graduating from Ohio State, he took a series of educational degrees, which included performing medical research at Case Western University, graduating from medical school at Ohio University. He completed a residency of 4 years at the Cleveland Clinic, a very prestigious place where the best of the best are trained. Subsequent to that, he completed a critical care fellowship at the Cleveland Clinic that lasted a year. And his very first job was at Mount Carmel. If you look at this and add it up, it is a series of 17 years of higher education. And the state of Ohio wants to convince you that despite the 17 years of trying to be a doctor, that he decided to end people's lives so that they live in 5 minutes as opposed to 10 minutes. I'll tell you right off the bat, we dispute that these patients were not terminally ill, and you're going to see that clearly. In fact, it's always been everyone's position that these were terminally ill patients until much later. So, how did we all get here? I think a good starting point is right here. These are all of the palliative withdrawals that we were able to get from Mount Carmel's hospital. And it covers a list from 2014 all the way to the very last one, which occurred November 20th of 2018. As you see, one of his first palliative withdrawals are 200 micrograms of fentanyl, 200. And then he met a patient by the name of Tracy Young. Tracy Young is someone you will hear repeatedly throughout this trial because it is a watershed moment in this case and in the experience of Dr. William Husel. Tracy experienced what is known as a bad death. She was gasping for air. She was suffering, trying to lift herself up as she was being palliative extubated. William initially gave her 500 micrograms. That didn't work. She continued to suffer in pain. Gave her another 500. Continued to suffer in pain. Then he gave her 1,000. That still wasn't enough. And then he gave her another 500 more. Tracy Young went on to live another 9 days after the fentanyl had exited her system. This experience is critical in this case because, as you can see, 2,500 micrograms is higher than each and every person given thereafter. So if the intent is there to kill, you would think that the dose would be even higher than 2,500, not less. And that is going to be the most critical thing that you should keep in your pocket as you go through this case. Doctors learn 3 ways. One through their education. The other one is experience, which is this. And then also through research. medical journals, articles, studies, things that are done. Because while we call it a science, it is scientifically based, there are nuances to medicine. And every doctor is different. Equally qualified, equally trained doctors will think completely differently on many, many different occasions. And that will be, nothing will ring truer than that in this case. So take a second and imagine this. Your very first bad death, and that's experienced in this case. And I want to tell you something else. Once William Husel was a suspect in this case, and he was immediately fired. He had one of his civil lawyer try and get the records of Tracy Young. And you're going to hear this evidence where after attempting to get the records of Tracy Young, which is the watershed moment to show, I'm not a killer. This is the reason why I give these doses, because people suffer in pain. And I'm the one at bedside. These nurses are the ones at bedside. They know what these patients are going through, much more so than anyone else. Now, having said that, the hospital responded they had no record of Tracy Young dying at Mount Carmel Hospital. You'll hear evidence, ladies and gentlemen, that they knew about Tracy Young early on in the investigation and never even disclosed it to the police at its onset. And I'm going to go over that in just a moment. But as you can see, after Tracy Young, the different patients required different doses based on their physiology, based on how sick they were. I'm going to go over with you a list of factors that are very common in determining what a patient should receive based on their current state. And each and every patient was different. Some never even got fentanyl. Some got other types of medicine. So this case really unfolded and came to light in October of 2018. And this was by a patient of the name of James Timmons. One of the very last patients. You heard my colleague mention that William was Doctor of the Year in 2014. That's because of the excellence that he provided of patient care and actually hard work. He was also nominated in 2018, again. But of course, things didn't end up working out for him. You're going to see, ladies and gentlemen, that upon James Timmons being given the 1,000 micrograms of fentanyl, there's a process of how the orders go in. And Ms. Grubbs didn't explain that to you, but I'm going to explain it to you right now. So, first off, the doctor orders the medicine. But what you have to realize, in the ICU, there is one doctor for 30 beds. So the person that coordinates the care is the nurse. We've all been to hospitals. We know that the person you see the most is the nurse. They're the most involved in your care. They know how sick you are. And there are a series of safeguards that are set up to prevent this from happening and to actually ensure that patient safety is a must. And let me tell you how it works. Dr. Husel will order the medication. The nurse will either enter the order if it's a verbal order or retrieve the medication from a machine that's called a PACES machine. Okay? After that, a pharmacist is supposed to verify the order. Now, there's going to be a lot of debate with pharmacists in this case. But a pharmacist is the person in charge of the medications. It's a 50-50 responsibility between the pharmacist and the doctor. There are no pharmacists on trial here, but yet they're 50% responsible for every single dose that's given. Subsequent to all of this happening, there's the attending physician, who is the designated doctor in charge of the patient's care throughout their stay at the hospital. Kind of like a quarterback, so to speak, of their care. Now, William Husel was not the attending for any one of these patients, any of the patients in question. So essentially, when a patient passes away at a hospital, the attending physician will review the medical records and then actually write out a cause of death and issue what's called a discharge summary. It's basically, this is everything that happened here in the hospital. And that's why I showed you the picture of all of those people. Any doctor giving these orders relies on these safeguards to take place. Now what's fascinating, folks, is that you're going to hear that doctors don't even know where the nurses get the medication. They know it's coming from a machine. They don't really get involved in the process. They give the order, or they write the order, and that's it. They monitor the medication after it's administered, and all of those things take place. But as far as getting the medication, drawing the vials, doing all of that work, that's all done by the nurse. Now, you're going to hear that Mount Carmel had a big problem. And that was that there was a glitch in their system that allowed the nurses to do what's called a scan to order, which basically means they scan the vial and they enter in the order at the same time, and somehow, unbeknownst to William Husel and any other doctor, including anyone else involved, the orders never went to the pharmacy. Now that's not with all of the patients. It's only with a couple of patients. But it was when this happened in Jeffrey Timmons' situation that this all came to light. A pharmacist's main job is to be the keys, the gatekeeper of medicine at a hospital. And there's a huge problem when controlled substances are not being controlled. Immediately upon this happening, one of the pharmacists named Talon Schroyer, he immediately raised the issue. Wait a minute. And the way it came to Talon Schroyer's attention was a nurse call and said, hey, I just want to make sure that you're aware we did this order. But he looked at the system and didn't see it in there for him to approve. That's a huge, huge problem. You don't have control of controlled substances. Pharmacists can face criminal penalties, so can a hospital. They can lose their funding for Medicaid and Medicare. And you'll see, ladies and gentlemen, there's no way in the world that a hospital will be able to survive, especially Mount Carmel, without seeing Medicare and Medicaid patients. Huge, huge problems. But it wasn't a patient harm issue. This was considered a diversion issue, meaning they thought maybe they're stealing drugs over at the ICU. That was a suspicion of Talon Schroyer. And he spoke with his colleague, Greg Dresbach. Now, they're going to tell you that they were concerned about the high doses, but they're also going to admit that this was really about, Talon Schroyer will say, I thought it was diversion. There's a huge problem with diversion, and that was their main focus. He was so focused about this murder and this high dose that he mentioned it to his supervisor 5 minutes as he was getting off shift. He didn't stop, he didn't pick up the phone, he didn't leave and go talk to Dr. Husel. No one spoke to Dr. Husel. And then, at that point, that's when they first did what's called a voice report. It now gets into the system. It's now official. Something's going on here.
But it was done by a woman named Katie Barja, who worked in risk management. Essentially, James Timmons, or Talbot Shore, told his supervisor, Randy Miles. Randy Miles escalated it to Katie Barja. So what happens now is she enters this in at what's called a level 4, which has two significant things. One, it means it's not a patient care issue, it's not an emergency, so nobody got hurt here. There's no life-threatening situation. And two, it stays within Mount Carmel. It does not go to their parent company, which is Trinity Health. That's critical. So if you think about it, this is just a normal concern. Now I want to tell you why, and I want to point out to you why you're going to see that this was not an issue about the high dose, because everybody knew William Husel was very aggressive when he came to pain meds at end-of-life care. He was comfortable with this amount, with these amounts, because of his anesthesiology background and his experience. And you're also going to hear and find out that Talon Schroyer had previously approved Randy McDonald's medication for 1,000. So as you can see, 1,000 now, it's not the same, it's not a concern. He had already approved that. He also had approved previously Bonnie Austin's medication, who's another patient in this indictment. You're also going to hear about 6 months earlier, there was an email sent out to all the pharmacists about being concerned about these high doses for various reasons. One, there's no policy at Mount Carmel. The pharmacists had no guide as to what the max dose is. Neither did the doctors. Neither did the nurses. You heard Ms. Grubbs tell you about a subset. Those are recommendations, and those are in a policy that basically does not advise the doctor, does not take the discretion away from the doctor when he or she sees that their patient is in pain. There are no max guidelines at Mount Carmel at this time. And this was a discussion amongst pharmacists for months. And they all knew about it. And not a single one raised a concern or yelled, "Murder!" These are trained professionals on the pharmacology of these drugs, and they didn't raise a single concern. So what happens next is Sandra Castle. Sandra Castle is also a scandal lawyer, a completely different nurse. And it doesn't go to the pharmacy again. At this time, Randy Miles, the manager at the pharmacy, knows they got a big problem. More drugs are going out without the pharmacy even looking at it. So then, after that, the second voice report is brought up to the head of medicine, a Dr. Swanner. And it's made he's made aware of this issue. They don't take Dr. Husel off the schedule. They don't even go speak to him. They don't say a word to him. They're not concerned with murder. And then the next patient happens, Melissa Penix. Melissa Penix is the last patient. Randy Miles brings it up again, but this one actually got what's called retrospectively reviewed, which means it was looked at by a pharmacist and approved after the drugs were administered, which is also an acceptable thing in certain situations. So all of this is going down with all of these different people involved, and it's finally at this point that they have a meeting and decide to put Dr. Husel on leave. Again, not a single person has come to Dr. Husel and talked to him. and say, hey, why are you giving these amounts? What's your reasoning behind these doses? Can you explain yourself? Not a single opportunity to defend himself or his reasoning. The next thing that happens is after he's put on leave, they call him in finally. And he meets with the head of medicine and the head of ICU. And they have this meeting, and they talk to him about his dosing. And they ask him, are you comfortable? Why are you issuing these doses?
Your Honor.
And this is his explanation.
Hold on, we got an objection.
Move to approach.
Yes. Come on up. Ladies and gentlemen, Ms. Shaver's going to come over and talk to you all for a second. Okay? Ask her about her two daughters.
Good morning, guys.
Let's go. Can you go to the side?
Nice weekend, enjoy yourself. Yeah.
I took my 4-year-old out to lunch.
Oh, did you have a day off this week? I did. I coached my daughter.
You may continue on.
Thank you, Your Honor. So, as I was saying, he gets called in for the first time. They then don't accuse him of murder. They then determine that they're going to create a policy for dose amounts, and they ask Dr. Husel if he'll be part of that committee. This is after knowing these things. There's no murder case. None whatsoever. 2 days after this meeting, they renew his privileges at the hospital. Then something happens. A meeting is scheduled to discuss the pharmacy concerns. And things start unfolding and realizing how big a problem they have at the pharmacy and what that will mean to the future of the hospital. It's at this point where it goes up to Trinity Health. Trinity Health has a director of medicine review one sheet of paper, a spreadsheet. No medical records. She couldn't access the medical records. But once she actually had this document, and with no real clinical care experience, she made a determination that this was euthanasia. And therein started the downfall of Dr. William Husel. Let me get this up. So, the very first thing that Mount Carmel does is they go and hire one of Columbus's best criminal defense attorneys. Doesn't need it. They're now realizing they have no control of any controlled substances, and they are in immediate jeopardy of losing their funding from Medicaid and Medicare. And this defense lawyer sets up a meeting with his former boss of 14 years. This attorney is a very well-respected member of this legal community and set up a meeting, a private meeting with his former boss, and outlined the case for them and brought them the case of Dr. William Husel. This is not how your typical cases get developed. But that's exactly what happened in this case. And that's an undisputed fact that you will all hear about. Once this occurs, at the same day that they're running this, Mount Carmel started this thing, and actually Trinity Health, which is the parent company, started something that is called Project Lighthouse. They even had a code word for it. Project Lighthouse. It's as if this hospital was in search for their moral compass in a perfect storm that would only sink one man. And that one man was William Husel. Upon this Project Lighthouse, they immediately discovered Tracy Young's records. But they didn't give it to law enforcement. In fact, they gave them very little. Besides the case, they gave very little to support it. And they immediately terminated William Husel's employment. What happens next, ladies and gentlemen, is about to shock you. The very first person to interview witnesses to a murder are not detectives. They're human resources at Mount Carmel, followed by risk management by Mount Carmel. Then they let the detectives talk to the nurses and pharmacists. And when they let detectives talk to the nurses and pharmacists, they don't even give them the patient's names. They don't give them the medical records to look at how sick these people were. They don't give them any information other than the dose amount and the date. That's what a detective is sent into a hospital with to determine what a murder is, whether a murder occurred. That is the information they're given. And ladies and gentlemen, you're going to hear they could have easily gotten the investigative subpoena and gotten all that information like that. But the one dictating this investigation is not the police department. It's Mount Carmel. And you will draw no other conclusion than that because that's what the evidence will show you. Once that occurs, the attorneys give them certain information, which is their interactions, who they talk to in their investigation. And then they create the very first new revised palliative ventilator withdrawal policy that sets a maximum dose. William Husel never had the benefit of that. They then get the comments of Ms. Toko Bradley on the 16th, after she has the access to the records now. Now she's got the records, and her position slightly changes. She says this might have been part of his pharmacology to alleviate pain so that they didn't suffer and they ended life in a more humane way. That was her opinion after the initial euthanasia concept, but they never disclosed that to the police. Mount Carmel never describes that change of position to that. Instead, things go forward all ahead with Project Lighthouse. Now, Project Lighthouse is more than just an investigation. It's an outright attack, a full frontal attack on William Husel, which includes a media playbook. How are they going to explain this to everyone? How are they going to deflect? How are they going to make him out to be a villain? You may think those are just my words. They're not. one of the determinations that they have to do is create this playbook, and it comes straight from the top at Trinity Health. Our plan should include a playbook we'll follow once we decide to disclose all the facts, whether due to leaks, meaning do they leak this to the media secretly, or in a more controlled way in collaboration with the prosecutor. Melissa's already assembling this playbook for the internal and Columbus community. That's you folks. So let's be sure we have it on the national level too. This will include ensuring senior leadership team is prepared to reach out to key stakeholders. And then they have this discussion. This is a confidential document, never seen before by anyone. And it says, who is the villain in our victim, villain, vindicator, crisis communications narrative? Choices, Husel, Husel nurses and pharmacists, culture at the ICU night shift, the act of killing someone with pain meds. And then they have discussion topics, which include Husel is popular with some staff and may even remain popular as a martyr for dying, even if indicted. Ed's decision, Ed is the president of Mount Carmel, was Husel's the primary villain, included pharmacists, not the one who reported the voice report, and the nurses, not with the two preceptors, those are nurses in training, as co-villains who made poor decisions and chose to ignore a series of protocols and safeguards. Ladies and gentlemen, Trinity Health initiated this, and when a $20 billion corporation wants to make you out to be a villain, that's exactly what they do. Some of the other topics include, prosecutor has already lauded our response and may do so publicly. If we want to appear contrite over this, overdoing our response may diminish the contrition. Some will say our culture and training led to this, and we're as much at fault as Husel. Ed's decision is to factually describe the timeline in a way that's transparent and accurate. Well, that was his decision. Include the October triggering event with the context that it was out of character for Husel and appropriately referred to peer review. Yes, the October event was out of character for William Husel. This is what was in play behind the background and behind the scenes, with every press release, every press statement made. Here are some of the way they changed certain things. Version 1227 versus less than 2 weeks later. They basically said that this former employee ordered fatal doses of pain medication. It was later changed to significantly excessive and potentially fatal doses. That's a huge difference of what's potentially might happen, might be fatal, versus fatal. Everyone always remembers the first statement, not the second, third, or fourth. And that's how this narrative slowly changed. They then had a series of articles where healthcare professionals were killing people to generate interest amongst the media, to paint him out as a villain. This is why we don't want you watching the news, why we don't want you researching this case, because you're going to learn everything you need to know right here, right from that witness stand. And then there's the issue that they face of what is called CMS, Center for Medicaid Services. And if you look at this, we continue to cooperate fully with the Ohio Department of Health Center of Medicare and Medicaid Services, and other regulators to investigate Dr. Husel's actions. And then at the end, over here on the second paragraph, as a result, Mount Carmel West has asked, and we anticipate will be asked to submit an action plans to improve the pharmacy process. Issues at the pharmacy. They act like William Husel worked in the pharmacy. And this is where all this case unfolds. So as you can see, they added a new protocol to set maximum appropriate doses, and they realize at this point in time they are going to be placed in immediate jeopardy of losing the ability to see Medicaid and Medicare patients because of what's going on at the pharmacy. Ladies and gentlemen, as you can see, these narratives change over time. And then on 116, immediate jeopardy is they get placed on immediate jeopardy, and they get their official notice on 130 that they are in immediate jeopardy. Yet the investigation continues in the background with little to no information given to the detectives. They have a hospital telling them he's a killer, these are excessive doses, but that's not what the healthcare providers are telling them. Every nurse, every pharmacist interviewed that was participating in the care of these patients expressed their opinions. They're all independent healthcare professionals who did not have issues with these doses until it was brought to the attention of the pharmacy that they were being circumvented. Now, ladies and gentlemen, it's within these set of facts that William Husel now stands trial for his life. Objection.
Yes, ladies and gentlemen, you can disregard the last statement.
It's within these facts that William Husel stands trial for murder. Now, there are numerous obstacles and issues with the state's case, and there are big, gaping hole issues. For example, let me set this up. I want to cover with you a couple of things. And I remember during jury selection, there was this whole thing about could you follow the law even though you morally disagree with it. And I told you, we're not going to ask you to not follow the law. In fact, we're going to ask you to let the law be your guide. And some of the issues that you're going to cover or go through in this case deal with what I call pick. Because essentially you get to pick which one of these, as you weigh the evidence, will clearly show you that William Husel is innocent. Purpose and intent mean the same thing. You'll hear it interchangeably through the jury instructions that the judge is going to give you, and as we all agree, you're to follow the judge's instructions. And causation. Okay, so in light of that, the first thing that I want you to look at is there's going to be a lot of talk about potential side effects of these drugs. So, what does the side effect, they have to prove, remember we talked about the burden of proof, that the side effect occurred. There are a couple of things that you need to know right off the bat. And when it comes to respiratory distress, depression. Forgive me if I get smell something. And arrest. And you're going to need to know these terms from the very beginning of this trial. Respiratory distress is what a person suffers as they're going through end-of-life care. The agonal breathing, the gurgling, the death rattle, all of these things. That is what a healthcare provider looks at. Their distress. Are they in pain? Depression means slowing down the breathing. And arrest is when you stop breathing. One of the potential side effects of fentanyl and these benzodiazepines are respiratory depression. But the issue is, did respiratory arrest occur? And I submit to you, ladies and gentlemen, that even though there are tons of healthcare records in this case, you're not going to see it there at all. And that is their burden and their burden alone to prove to you. And they will not be able to do it. And this side effect goes into William Husel's intent, and it also addresses the issue of causation. I'll explain what I mean in a minute about intent. This is something you're going to need to know as well. And I hope you can all see this. There are two types of life support. The ventilator, which everybody's already talked about a lot. And here, I can take this down. No, not that. Not that. Leave that there, please. This one. And what's called vasopressors. Vasopressors are basically medicine that's inserted through one of the tubes that gets the Now, there's something you need to realize. Once a case gets started, and that media starts going, there are all kinds of stories. Many of the patients gave interviews on the media, and each and every one of them filed a lawsuit against William Husel in Mount Carmel. Now, one of the other things you should know right off the bat is that each and every one of these witnesses were spoken to after the hospital spoke to them. Meaning, the police didn't go speak to these witnesses in murder cases first. The hospital did. Mount Carmel, in their Project Lighthouse, had a script that they had their doctors use to call and specifically disclose this information to each and every patient. And they did so before the police got to speak to them. Many of them had already gotten lawyers before the police actually spoke to them. In fact, there's a whole slew of them that were spoken to at their lawyer's office. Lawyers who have a financial interest in this case. They get a percentage of whatever they recover on behalf of these patients. And it happened after. It's head-scratching. If this is going to be a head-scratching investigation to you, and you're going to wonder, how did the police allow the hospital to dictate this investigation? So, we submit to you that the evidence will show each and every one of these deaths, the issue is going to be cardiac arrest, in terms of the death. So basically, your heart stops, you die, you're dead. So now the issue before you, ladies and gentlemen, that you have to determine is, did the heart stop first and then the patient started breathing and stopped breathing after? Or did the patient stop breathing first and then the heart stopped after? Why is that important? Because these drugs, they're alleging that it's respiratory depression. So if their heart stopped first, fentanyl and whatever drug they got was irrelevant. Because it's the effect, the target that they're claiming the side effect is the breathing. You understand? This is what you will be listening to and trying to determine as this case goes. Again, you're not going to be able to know that. There's some evidence in the records that we will point out that will show a heart stop first. But again, we don't have to prove anything. We do not have that burden of proof. They will have to prove to you that these patients incurred a side effect and that they stopped breathing before their heart stopped. If you're dead when your heart stops, you're dead. And all the drugs in the world aren't going to matter. That's the issue here that is not provable in any way, much less beyond and to the exclusion of every reasonable doubt. You are going to have a doubt, and then some. Doubt upon doubt upon doubt. Now, the side effects, ladies and gentlemen, there's a lot of debate in the literature as to what the actual side effects are. Many journals list that respiratory depression is a rare or uncommon side effect to these medicines. Certain ones will use it as uncommon, some as rare. That's a huge issue here. There are brilliant doctors throughout the world who can't agree as to whether side effects occur, whether they're common, whether they're definitely going to happen. And again, we're getting into the unknown and world of second opinions. Second opinions are not beyond the exclusion of every reasonable doubt, ladies and gentlemen. Especially when there's tons of literature out there that say that respiratory depression is a rare or uncommon side effect. It's a side effect, but it's like aspirin or any other medication. There's tons of different potential side effects that happen, and they have to prove that the side effect occurred. They have that sole burden. So as you go through the evidence, you have to find out where's the evidence that shows the side effect occurred. There's also literature that say opioids do not hasten death. And again, as I mentioned to you, doctors learn through their education, experience, and research. There are journals out there that say, contrary to the belief, numerous studies and reviews of opioids and sedatives worldwide are clear that they do not hasten death or alter survival. When given after withdrawing ventilator support, they do not hasten death. Indeed, even in those fully dependent upon mechanical support, opioids and benzodiazepines enable breathing to be more comfortable and to continue longer after ventilator withdrawal due to their beneficial effect on the respiratory efficiency. Let me tell you what that means. Person gets off the ventilator, they start gasping for air. That takes their reserves, their energy away. When they have the fentanyl and the sedative medications, that calms their breathing down. Calms them. So they breathe naturally. And there is research out there that you'll see that shows that people sometimes live even longer. They live even longer because of the opioids. Because now they can rest and breathe naturally. And their reserves aren't depleted. Meaning, you can only breathe like that for a short period of time until you tire out and die. And the opioids actually alleviate that. This is not something made up by William Husel. This is a well-established issue that members of Mount Carmel told the police about. But they didn't do anything to follow up on that. And you'll see that as the case unfolds. It's a vast, well-known fact. But there are doctors on both sides of this issue. And I have to be fair and tell you that. The most brilliant minds in the world cannot make that determination, but they want you to. They want you to make that conclusion. And I submit to you, ladies and gentlemen, it's just not possible under the high legal standard of beyond a reasonable doubt. There are no maximum doses in the industry. You heard Mr. Zion tell you that during jury selection. It's true. There's no set doses because medicine believes it's the doctor at the bedside who's best to determine whether this patient needs more medicine. They want you to take medicine out of the hands of the doctors and nurses at bedside and give it to a prosecutor. And that's essentially what this case will be about, too. Then there's this thing called the Doctrine of Double Effect. The maximum doses strictly go to Dr. Husel's intent, as well as the issue of causation. No policy strictly goes to his intent. If there's a policy with a maximum dose limit, don't you all think that that's the fair thing for a doctor to determine, okay, that's the line I can't cross, so therefore, I will not cross that line. And you can make an easy determination whether in fact this person is guilty of killing someone by way of medication. But absent anything in the standards, that there's no maximum dose in medicine, or the fact that there's no policy setting the limit, and no one spoke to him. Never. Until November 26th, after all of this is over. They all knew about it. No one spoke to him. You know where they spoke to him? He's Doctor of the Year 2014. He's nominated for Doctor of the Year 2018. That's them speaking to him. The medical studies address the issue of intent and causation. All you need, remember, pick purpose, intent, and causation. All you need is one of these to make the determination that the charges were not proven. Then there's this doctrine of double effect that is a staple in medicine, brought all the way from St. Thomas Aquinas. And that basically says that if a doctor has a good intent and a secondary effect happens, like death, that it is fully permissible so long as the doctor's intent was to do what was intended. In this case, comfort care. If William Husel intended on giving comfort care, and the outcome or the cause of that comfort care was the death, it falls under the doctrine of double effect. The doctrine of double effect explains how the bad consequences of an action can be considered ethically justified if the original intent was a good intention. The DDE aims to describe the best practice when a clinician must distinguish the positive benefits of an intervention against the known foreseeable but unintended risks and burdens of such therapy. And that goes for everything. You go to surgery, you know it's high risk. The intent is to save you and to do something, but ultimately a mistake happens or something happens and you die. Same thing. It also applies to comfort care. The doctrine states that a doctor uses measures, usually opioids, to alleviate symptoms at the end of life, which might, as a secondary effect, shorten life provides the doctor's intention is the good outcome of symptom relief rather than the bad. The traditional application of the double effect indicates that one can administer pain meds even if the patient's death is foreseen. Unintended consequences. There's so much area here for you to find reasonable doubt. It is our position that these drugs did not cause the death from, one, his experience, two, the articles that are contrary to that position out there. But even if you find that that was the issue, he is ethically justified in giving these payments. Sometimes the relief of suffering, the intended good effect, also has the potential bad effect, which is foreseen, but not the primary intention, hence the double effect. The doctrine of double effect states that a harmful result of treatment, even resulting in death, is permissible if not intended and occurs as a side effect to a beneficial action.
May we approach?
You may. Ladies and gentlemen, entertain yourselves there for a second, unless you want the dreaded white noise. Trust me, you don't want it. Ms. Schaefer? Yeah. Tell me when you're ready, Sam.
All right, Your Honor.
Okay.
Ladies and gentlemen, we submit to you that the doctrine of double effect specifically addresses Williams' intent. Now,
Objection, Your Honor.
I'll give him the transition. I assume you're moving on?
yes, I'm moving on.
Move on.
Now, ladies and gentlemen, so does Williams' experience. And that specifically issues the issue of intent and causation. This can and should never be ignored. Now, in light of that, there's also the process. You're going to hear, ladies and gentlemen, as I explained earlier, that these safeguards are put in place to protect the patients and everyone else involved. Now, what's also interesting for you to note, ladies and gentlemen, is that doctors rely on this. So, for example, there were 2 occasions throughout all of this time where pharmacists came to William Husel to question the issue of the dose And that was because of a fentanyl shortage. Not because of the dose amount. You'll hear evidence, ladies and gentlemen, that one of the patients was ordered 1,000, and the pharmacist suggested 500 because of the fentanyl shortage. Not for any other reason other than the fact that there was a shortage of fentanyl. Now, if you're the doctor giving these orders, and pharmacists, and you know pharmacists are coming to talk to you, this is all out in the open, ladies and gentlemen. As it relates to murder, you're not going to hear any evidence of some doctor walking around with a syringe in the middle of the night, poking people, or doing anything crazy like that. Every single order was given, every single order was in the records. William Husel, everything is out in the open. There is nothing in terms of this being some hidden, suspicious, nefarious act. In addition to that, on Daddy Millette, one of the pharmacists came as well and questioned because of the fentanyl shortage. Now, this process should give and address the issue of intent as well. Because William Husel's not aware that the nurse is doing standard orders, and you're not going to hear any evidence of that. And William Husel's not briefed as to whether the pharmacist gets the order or doesn't. It's if the pharmacist intercedes or interacts that is when it becomes an issue. And you'll see through the evidence that it's happened in the past. So one is to know, my doses are being checked. Everything's okay. I'm doctor of the year, and everything is going as expected. Now I want to address finally the patients. I think the patients warrant their own consideration. I didn't want to get too much into detail. But there's things that you should consider. When evaluating this evidence, you've got to realize that pain management in the living is very different than pain management in the dying. You have to get ahead of the pain as a person dies. You don't want to see them suffering and then address the issue. I know Ms. Grubbs addressed that during her opening, and we respectfully disagree. And so do doctors. And that's what the evidence you're going to see in this case. There are numerous factors that a doctor takes into consideration when a person is dying, as opposed to whether they're healthy. If their blood pressure is normal, the meds can go through the body relatively quickly. If it's low, a higher dose is needed to compensate for the fact that it can't go through your system before it gets to your brain. That's a factor you're going to need to know. Their pH levels, their acidosis, that's another factor. There are numerous factors, including the weight of the patient, their tolerance, a whole slew of factors that you're going to find and evaluate as this goes through. It's not just a tolerance and weight issue. It's much more complex than that. And it's also complex in the fact that who's to say they're suffering when they can't speak? The family and the nurse. And that's what's at issue here. All these incredible doses that were killer doses, 2 of them required more additional doses. 2 of the charged cases here required more because they still were in pain. Mr. Timmons was still in pain. Danny Millennium was still in pain. They got more doses, as did Brian Hayes. It wasn't enough. There's that hidden factor as well. Mount Carmel has services in an area that's in the epicenter of the opioid epidemic. And you heard a lot of talk about fentanyl overdoses during jury selection. But the fact of the matter is, ladies and gentlemen, those drugs are different. We don't know what comes from Mexico and China that hits the streets. We don't know what those drugs are, whether they're synthetic. We don't know if other chemicals are put in these drugs that are on the street. Very, very different. And you should not compare the same. A good example would be Ryan Hayes, who was initial drug screen from urine, did not show fentanyl. His autopsy showed carfentanil. That's an elephant tranquilizer. An elephant tranquilizer. And you will hear that that is 100 times stronger than fentanyl. This is what a doctor has to anticipate and deal with, and then be called a murderer. Factors in dying that doctors considered are, of course, the pain, the suffering, which includes that of the family, and respiratory distress. And remember what I told, how I outlined the different respiratory terms. The dose factors are numerous, not just one or two. They're going to be numerous, and that will all be laid out for you in the course of this trial. And this is just a sample of some of the health conditions. Ms. Grubbs told you some of these people could have left the hospital. These are all 14 patients. Troy Allison had 4 cardiac arrests in the hospital. He had 2 in the emergency room. The doctor walked away in the emergency room for a few minutes, and he died again. They had to bring him back to life. They had to give him, ultimately it was determined he had 5 organ failures. They don't call them your vital organs for nothing. And just one vital organ failure will kill you. He had 5. He was on vasopressors. Vasopressors are what I explained to you earlier, helps the blood pumping, keeps the blood going, the heart. But look at his last blood pressure, 74/33. He was actively dying on life support. This is after the vasopressors and after the ventilation, breathing for him. He's dying. Tubes coming out of his body. One thing you're going to learn about these vasopressors is when they're turned off, the effect is 1 minute to 2 minutes. We submit to you, ladies and gentlemen, that a majority of these deaths occurred because the vasopressors were turned off. Look at these blood pressures. If the vasopressor is keeping your blood pressure, your blood pumping, heart pumping, and you turn them off, it's seconds to minutes. No one is going to be able to tell you exactly how long. Jeremiah Hodge had 4 cardiac arrests in the hospital. 4 for Danny Millette, 5 for Bonnie Austin. Look at all of these cardiac arrests. The heart is stopping. And remember what I told you about what happens first, the heart stopping, or whether you stop breathing.
Okay, let's get back to opening statement, please.
And as you can see, the pH levels. This is something you're going to learn about. And let me just give you a brief look at this. pH levels are guided from 8 to 6.8. If it's too high, you die. If it's too low, it's death. Look at the pH levels of some of these. 6.8 is death. Some are walking miracles. And some are very close to death, as you can see. Very different than what Ms. Gross told you about. And all of this will come out in the trial. Ladies and gentlemen, the state of Ohio is telling you that this is medically assisted death. This is a case about medically assisted death. When, as the evidence will show you, that nothing could be further from the truth. A set of circumstances put William Husel here, but the effects and everything else will be clear to you. And please remember that standard of beyond and to the exclusion of every reasonable doubt. We submit to you that it wasn't medical assisted death. He was giving medically assisted in living. These patients had just moments left in their lives, and he assisted them in living well. You can't hug, you can't hold your loved one with tubes coming out of their body, looking like this, in excruciating pain. At the end of the day, ladies and gentlemen, this is a case that does not belong in this forum. And you will recognize that if you keep an open mind and listen to all of the evidence in this case. You're also going to see a determination of how this case, once it got to the police and once it initiated, how it changed, the narrative changed. And now you know why. We hope that you keep an open mind. This is the most important day in Dr. William Husel's life and that of his family. And we thank you for your attention.
Thank you, Mr. Baez. Can you remove the, I like to see the jury when I talk to them.
Sure. Sorry about that.
I don't control that.
Okay, ladies and gentlemen, let me shut down. Okay, we're going to reach the next phase of the trial. I'm going to do a little bit of an explanation about what goes on in the next phase. It's getting close to the lunch hour, and I don't think you really, Mrs. Zion, I don't think you heard all about evidence in voir dire, the cherry pies theory, and that talked about one concept of evidence. I'm going to try to do years with the law school here pretty quick, okay? When they talk about direct and indirect evidence, that's how it's acquired and what you do with it, okay? Evidence can come in all different formats. There are photographs, there are records, there's live testimony. Okay, all these can be deduced for you so that you can evaluate that part of the evidence. When they were talking about the cherry pie, that's how you interpret the evidence. Direct evidence is what we see or hear. We use our senses to acquire. I felt a hot stove would be direct evidence. Okay? The indirect evidence, the cherry pie scenario where you heard about, you know, you come in, there's crumbs on the face, and, you know, the missing piece of pie. That's circumstantial evidence. It has equal value with direct evidence, and you can make any inference you want off of the direct evidence. You cannot make an inference upon an inference. Just because it looks like the cherry pie was eaten, you can't assume that he also had a glass of milk. Does that make sense so far? Okay? Now, throughout the process, you'll see exhibits. We'll be doing some foundations, and we're going to be dealing with some experts. So let me take a little bit of time about experts. Generally, one can't give an opinion unless they have some special training. Okay? That special training can be in all kinds of areas. Okay? And it's the lawyer's obligation to present to you what their credentials are. We talked about the CV and voir dire. That's their resume. Okay? These are all types of things that you will see. Now, with any eyewitness or any witness on the stand, you evaluate their credibility. Now, you use the skills you use in your daily lives. You know, the way they testify, frankness thereof, their ability to perceive the facts. These are all things that I will tell you you can consider. Okay? With an expert, you can also consider their credentials, certification, experience. All those issues can be taken into consideration, and you as a jury will determine what value, if any, to give to those witnesses. Does that seem pretty straight up? I'm trying to do a year worth of law school here pretty quick, okay? Okay, now, in the process, there'll be objections. Some I'll rule on right away, some will go on the sidebar, okay? You're not to take any inference, and you listen to whatever instructions I say. If I say continue on with the questioning, then you can consider it. If I tell you to disregard, then you have to act like you never heard it. Okay? That's one of the gives and takes here. Does that make sense? Okay. I think that's pretty much good enough for right now. Periodically, if something comes up during the trial, I'll give you further explanations. Now, what I would like to do is break you early for lunch and start back at 1. Okay? Does that make sense? Because, 10 minutes of a witness, it just kind of just things, and I think poor Sam over here needs a break. I do look out after her, okay? So we're going to continue back at 1 o'clock, okay? Anything more before I excuse them?
Your Honor, just briefly, I think we agreed a 3:30 dismissal because of a birthday
Yes.
today, which,
We have a birthday today. We're not going to sing happy birthday.
right, but we will internally.
Yes. We will be festive with our festivities, even though they got to sleep in. Okay. Sorry, inside joke. Ladies and gentlemen, remember my admonitions I gave you earlier. They're going to be standard throughout. You're not to discuss the case. You're not to do your own investigation. You're to disregard the press, and the lawyers are going to avoid you. Okay? With that,
All right.
have a wonderful lunch. We'll get started at 1 o'clock. Since some people want to go home early. I don't know who that might be.
Judge, we'll have some housekeeping issues.
We have a couple things to discuss.
I don't think it's working.
Have a wonderful break, guys. Okay. Let's have everybody's attention. Okay, you have housekeeping matters you want to discuss?
Just a few things we'd like to put on the record.
Okay?
Sir, several articles were referenced in the opening statement. We believe these were a group of articles that were provided to us last night at, I think, 9:40. There's 30 articles that were sent to us via email by Mr. Lapidus. So we're assuming that's what that was. Of course, we didn't have time to review that prior to opening statements today. We'd also like to put on the record that at this point, we still do not have any expert medical reports besides the page and a half that was provided initially within the rule 21 days ago from 2 experts. We have nothing else. We have nothing else from any additional experts whose names were provided to us last week once we had started trial. So we wanted that to be clear on the record. He seemed to be implying that they would, in his opening, would have experts to talk about these things that he was showing the jury, saying that the evidence would show these things. So not that they have any obligation to put on anything, but so we just wanted it to be clear that those articles, we think, were the ones we were given last night and have not had a chance to review or even have our experts review, and that we have yet to receive anything from their expert witnesses.
Things from 2 weeks ago, 3 weeks ago.
Other than the page and a half. Yeah, so that's what we wanted to put on the record regarding that. Thank you, sir.
Okay, response?
Yes, sir. We will be having the expert report to them within 48 hours. I believe it's being prepped as we speak, so I don't want to say 24, probably be soon, but no later than 48.
Okay. Okay, everybody's made the record. Anything else? Other issues we need to discuss?
Nothing further from us. Actually, there is. We did want to have access to the record on an issue on one of the recent rulings.
The decision we just issued?
Correct.
On the motions in limine?
Yes, sir.
Okay.
Yes, Your Honor. In Your Honor's ruling, you ruled that testimony and evidence regarding the penalties and sanctions various nurses and pharmacists received as a result of these administrative hearings that occurred would be coming in as relevant to their credibility. I wanted to just lay a record to the court that the state's position in their motion, contra our motion, was that they intended to introduce this as a preemptive impeachment of these witnesses to get ahead. An analogy being introducing a prior conviction prior to the defense being able to list it on cross-examination. We wanted to make it clear and on the record that we at no point intended to offer any evidence of this at any point, whether it be via, in our case in chief, or impeachment. So we just wanted to lay a record that essentially, absent of us seeking to do so or opening any doors to that, we would ask the court to reevaluate or consider putting a predicate upon them being able to just essentially bolster their witnesses' testimony by giving them, I guess, further credibility to their positions regarding sanctions that may or may not even be relevant to actual issues beyond what they did as nurses or pharmacists and not directly related to Dr. Husel's care of his patients. It has nothing to do with credibility where we don't intend to attack it. If there's no attack on the credibility of your witnesses, they can essentially walk first and bolster their credibility out by doing that. I know that the rules of evidence speak to surprise for prior and consistent statements. I believe it's 708 or 607, excuse me. There's no surprise here. They know what the testimony is going to be, and they know what they and why they want to elicit this testimony about these sanctions that occurred. So, absent some form of surprise or them testifying in some surprising, inconsistent manner in which they did in these hearings, we just want to lay a record that they are essentially just going to be bolstering their witnesses and they're claiming it's to credibility. But we have no intention of attacking their credibility via those sanctions of any kind.
Any response?
Just 2 points that would be shocking, considering Mr. Baez's opening statement saying this was the pharmacy's problem, this was all laying it all at the feet of the pharmacy and their inadequacies and the nurses. Recall, Your Honor, we also amended our motion after Mr. Baez's voir dire last week when he, to several witnesses, elicited comments about licensure boards, about how if they'd actually done something wrong, they would have been in trouble, right? As if to imply, in this case, well, they didn't get in trouble. They all got in trouble. They all got investigated at least. So remember, we did amend after Mr. Baez's comments to the jury, and we believe the court's ruling on this issue is entirely correct. Thank you.
Okay. Now that on my issue, you showed a couple documents. One day I couldn't read it of 12/17/2018, and the other one was 1/12 of 19 relative to Trinity.
Yes, Judge.
Okay. How did you guys acquire that?
Through the civil litigation.
So another judge ordered that be turned over?
Yes, it was turned over. It was considered not attorney-client work product in the civil case. We subpoenaed it, and we received it and subsequently turned it over to the state.
And did you share it with the state?
Yes.
Okay. Back about a year and a half ago, I went through 659 peer reviews. Okay. Was this after that?
I'm sure it was after, because we didn't get it until about a month ago.
Okay. And did you share it with the state?
Yes. Immediately.
Okay. I was just curious based upon my previous decision, and I just wanted to know where it came from, because I don't know if anybody's going to ask me to reconsider that. But it's a little.
I don't think. Well, they have disclosed it in the other litigation. So the court found that it was not attorney-client protected or work product, and that's why it was subsequently allowed to be turned over to us.
Okay. And were the peer reviews also turned over?
Yes. When you say peer reviews, I'm a bit confused. What I showed was their press strategy playbook. There wasn't
Okay.
there wasn't an independent peer review that was shown, other than the one from the Trinity medical director.
Okay, that was the only thing you saw? Okay. I just wanted to know because I had previously ruled on certain issues. I didn't know if we had a problem.
Understood.
Okay, anything else for the record?
Not from the defense.
Not from the state, Your Honor, thank you.
Okay, 1 o'clock promptly.
Thank you, sir.
Member setup time, and are you going to need to make copies of what they showed the jury?
They gave us copies, sir.
No, I'm talking about for my court reporter, because he's referring to things throughout, and she doesn't have a copy of it. Okay? Mr. Baez, she's going to need to take some type of photo or something of everything you showed. As long as you keep the door closed, because the jurors will be walking in the hall.
Of course, yeah, of course.